Everyone. Well, thank you for joining. I don't have much in terms of updates. The main thing that we've been working on lately has been this 1099 issue in terms of dealing with the trust. I know the trust is processing the claims, but in our dealings with them, we've been doing this 1099. I told you about the call that we had with them last week, and so we're still working through those issues. We're optimistic that we're going to be able to get it resolved, but that is still not resolved. So as soon as it is, I will let everyone know. I want to start off by answering the questions that were submitted in advance. Then we'll have Chewy just go through and read them, and then we'll open it up, and anyone who has any questions, please let me know. Okay, so this is a longer question. It was an email that was written, and I want to go through and summarize it, and then let you know what the thoughts are. So the essence of it is that we as fire victims will not know what our total claim submission will be because there is no amount of emotional distress that is listed. So how will we know whether or not the offer is fair? And so I think that's certainly a good point, but I think the way to deal with it is that when the offer comes in, we will go through it with you and we'll say, here's what the demand was, here's what we think a fair amount for the economic damages would be, here's what we think a fair amount for the non-economic damages would be, and then we can compare that with what the offer is. So I completely understand the frustration. I wish the questionnaire had been done a little bit differently. At the same time, I do understand why they decided not to do or not to have a space where people could request amounts for non-economic damages. The reason being that if they did, the amounts would be very high and it would kind of skew everything. So doing it this way, the amounts that are submitted are for the economic damages. The trust assigns amount for non-economic damages. We'll go through it with you, tell you what the normal amount in these types of cases would be by way of settlement, and then you can make a decision whether or not you want to accept it. So in a nutshell, that's how the process will work. I understand it is a little bit different because in a normal mediation, we would be talking specifically about numbers. We would say, here's our number. We'd go back and forth. That's not going to happen here. It's going to be, we'll submit the economics along with an explanation of what everyone went through for the non-economics. Then at that point, they'll come back with an offer and you'll make a decision as to whether or not to accept it. Obviously, that decision is yours, but we will talk with you about it and explain what our thinking is, whether we think it's a good offer, bad offer, and why that is. So that is the first question. The next question, which is by far the one we get the most frequent, is when will we be paid? And again, completely understandable. I know people are frustrated with this. Believe me, I'm frustrated as well. Obviously, you know, you have suffered the losses, we have not, but you know, we are to a certain extent all in this together because we certainly haven't been paid. Obviously, that's something that's important to everybody, to get paid as quickly as possible. And in our position, because we work on contingency, we are also very eager to make sure that everyone is paid. Now, that's not the most important motivating factor, but I just want you to know it's not a situation where, you know, we've been paid, so there's no sense of urgency. We are in the same boat you are in terms of getting paid. We don't get paid until you get paid. So it's in our interest as well. I can assure you we're pushing this along. This is the most frequent issue that is raised. We're hoping that the November, December goal is going to be kept by the trust. We should know more next month. As soon as we hear anything, we'll let you know. I'm sorry, I don't have more information right now. How do we know what our payment amounts will be? And that's something where we know what the final number will be. In other words, once we make the submission, they'll come back with an offer. If you accept that, then that's the final award. If you don't, then we'll go to mediation and or arbitration. Eventually, we'll get to that number, and then the trustee will decide how much the initial payment is going to be. My guess is that it'll probably be about 50% in the first payment. It could be a little more, it could be a little less, but that's my best estimate as to how much they're going to pay out. Again, I don't know what the precise number is, and we won't know that until they come up with the budget. Next question, when will we know when the trust goes through the files? So my understanding of that is that the question is, when will you know when the trust has processed your particular claim? And the answer is, as soon as they do process it, they will either say we're unable to make an offer because we need more information, or they will make the offer. Again, at the outset, they want to get a certain number. Likely it'll be a couple thousand before they make the initial offers, but after that, it'll be on a rolling basis, first come, first serve. Next question, is there any estimate as to when they will start to finalize them? That really goes along with when will we be paid. I think that is going to be, at least according to the trust, they're going to start making the offers in November or December, and then as soon as people start accepting, then those payments will occur. Next question, will the Zogg fire have any impact on our claims? I believe the answer to that is no. We've spoken with a number of people about the Zogg fire. We're certainly involved in it. It does appear that PG&E's equipment was responsible. But in speaking with the Wall Street folks and even with the hedge funds that were the predominant owners of PG&E, there really is not any concern about Zogg having any impact. And the reason for that is that it is not a large fire as these types of fires go. It's certainly a very significant fire. It's tragic. There were 4 deaths. There are over 200 home losses, 56,000 acres burned. But when you look at it in the context of what the damages are going to be, my guess is we're looking at 300 to 400 million all in terms of everybody's involvement, the state, the counties, the insurance companies, and the individual plaintiffs, including the wrongful death plaintiffs. And so if you look at it in terms of that number, somewhere between 300 to 400 million, that's going to be well within PG&E's insurance. So it shouldn't have much impact, if any, on what's happening. Certainly in terms of the stock price, which we've been watching, and I'm sure many of you have as well, it has gone up since fairly substantially since it was issued. And there has not been any kind of significant drop as a result of the announcement that were made regarding Zogg. So there was a little bit of a reduction. I think it fell from 10.8 to 10.5 or something like that. But that's a very small amount. That's not significant. The only way that I think there could be a significant drop is obviously if PG&E were to start a fire that were very large, or if the glass fire were tied to PG&E. I'm sure all of you are familiar with the glass fire. That one is horrific. It's about 10 times larger than Zogg. That's going to be a multi-billion-dollar fire. That would have a very negative impact on PG&E's, not just their share price, but also what happened with the claim. So it does not look like glass was caused by PG&E. Our investigators have been out to the site along with several other individuals. We're not 100% sold on the theory that there was an electric fence at the winery that started it, but in looking at the actual ignition site, or at least what we believe the ignition site to be, we don't see any way that those lines could have caused it. The lines are nowhere near in terms of the place we've identified as the ignition point. So we just don't think glass is going to be a PG&E caused fire. And if that's the case, then at least so far in this fire season, there does not appear to be anything to worry about. Clearly, we're not out of the woods yet. There are going to be another probably 6 weeks of fire season, But given where we are right now, certainly this fire season has been one of, in terms of PG&E starting fires, one of the least destructive. Obviously, it's been the worst overall, 4 million acres burned. I know a lot of people are suffering, but in terms of PG&E caused fires, this has been one of the mildest that we've experienced in quite some time. Last question, and this is more of a nuts and bolts question. Is there a deadline for us to get our claim information to Singleton Law Firm? There is, because we have to submit everything as of right now by December 31st. So obviously we're going to need it in advance in order to get that submitted into the portal. I think that December 31st date will be continued, probably at least 90 days, but I wouldn't rely on that. As of right now, it's December 31st, so I strongly encourage everyone to try and get everything submitted by December 1st if they can. If not, at least 2 weeks before December 31st, because number one, we want to get all of your information submitted as quickly as possible. And number two, while we believe the trustee will extend that deadline, we don't have confirmation of that. And so I would hate for people to rely on an extension that doesn't come. Pardon me. So those are the only questions that we have submitted so far. Chewy, do we have anything submitted via chat or by email?
Yeah, I'm going to go through the chat now. There's a few questions that are about the same issue. First one being about the number of claims that have been submitted thus far by all firms and by Singleton Law Firm.
Right. You know, off the top of my head, I do not know that. That's not something that I've checked. So Chewy, if you wouldn't mind reminding me, I can do that and have that information available next time we do this. But right now, I don't know the answer to that.
Thank you. Will do. The other questions revolve around the 1099 issue. There's a few questions that want to know, let's say a 1099 is issued to the clients. What would that look like as far as the effect it would have on their final total payout after attorney's fees, costs, et cetera?
Yeah, so it wouldn't affect the payout. What would happen is if they decide to do a breakdown of damages. So let's just use hypothetical. You had 3 types of losses. You had real property losses of $100,000, personal property losses of $100,000, and non-economic damages of $100,000 with no physical injury of any kind. You were someone who was, let's say you were out of the state. You were traveling, and so you were not present, didn't have any kind of smoke inhalation, eye irritation, burns, anything like that. In that situation, what they would do is they would issue a 1099. Again, this is assuming this protocol or this procedure that they've outlined goes through. They would issue a 1099 just for the non-economic damages, the $100,000, because in that scenario, that would be the only one that they could definitely ascertain would be taxable. So they would issue a 1099 for $100,000. Now, again, that's assuming that you were actually paid that amount. In the event that it turns out that everyone only gets 90% of the final amount of their claim, then you would only be paid $90,000 for your economic damages. So you would get a 1099 for $90,000 in non-economic damages. Again, we see all kinds of problems with that. First and foremost, being that if people aren't going to be paid in full, we believe that the non-economic damages should be considered paid last. And we can do that by the trustee simply saying, we're going to pay economic damages first, because typically economic damages are not taxable. And if he made that general pronouncement, then that would give everyone flexibility to say, well, my overall award was reduced, so I should be able to take, and let's say everyone got $250,000 under that scenario, you would be able to say, rather than paying or 270,000, rather than paying taxes on the 90,000, you could say, well, the full 200,000, which is what the trust determined my economic damages to be, should be taken off the top, and I should only have to pay taxes on 70,000 as opposed to 90. There's all kinds of issues that go into it. Again, our tax expert met with the trust's tax attorney, and he just doesn't believe that their system is workable for a variety of reasons. And so we've explained that, we've gone over it, we're still fighting about it. But in the event that it went exactly the way that they're currently envisioning it, which again, I don't think is going to happen, that's how it would work. You would get a 1099 solely for the amount you were paid on the actual categories that are taxable. So we're talking about lost income, we're talking about rental income, and non-economic damages for which there are no corresponding physical injuries.
Thank you, Jerry. I have a question here that says, how long does it take the trust to review each claim, and how many trustees are working on all the claims?
Well, there's one trustee, and there are about 200 people total working on this process. In terms of how long it takes them to review, I don't know the answer to that. I know it obviously varies depending upon the type of case. There are going to be some that are very straightforward. There are going to be others that are very complex. I know they want to make it as streamlined as possible. Obviously, they want to make sure that everyone receives a full review, but at the same time, they don't want to needlessly bill. And they're being paid on an hourly basis, so it's kind of a fine line. That said, I think that it's going to be pretty quick because a lot of the information is going to be run through the database, and they'll be able to determine, is this claim within the margin of error? Is it outside? And then if it's outside, then they'll put eyes on it and start dealing with it then.
Thanks, Jerry. I have a question here about the attorney's fees. It says, will Singleton Law Firm get their attorney's fees all at once when the claimants get their first, let's say, 50% of their payment? Mm-hmm. Or will we also take a partial payment like they are?
Right. No, we get paid the same way that you do. It's a partial payment because the fee agreement it's a percentage of what you recover. So if you're awarded more than you recover, then we take the same reduction that you do. So if you only get 50% of the money up front, then we would receive our contingency fee percentage, 1/3 of that 50%. It's not like you got 50%, but we're entitled to 1/3, so we take 1/3 of that 50%. That absolutely won't happen. We will be paid the percentage of whatever you recover. So if you get paid in 3 separate payments or 2 separate payments, that's the way we'll be paid.
Thank you, Jerry. What price does the stock need to be at in order to fully fund the $13.8 billion?
13.5 billion. And it has to be just above 14, so about 14.2 or 14.3. It depends upon a number of factors that are involved in the sale, because different types of sales methods have different fees associated with them. So it's somewhere between 14.2 and 14.3.
Thank you. When will claimants know when their claims are actually submitted?
If you were submitted right at the beginning, then there was no requirement that you sign off on it. So your case could have been submitted and you wouldn't know. But going forward, you will know if your claim is submitted because you will be required to sign off on it. That's something that the trust put in, I think, late last month. And so that's the way we've been doing it.
Thanks, sir. There's a follow-up on the 1099 issue. The question here is, will both claimants and Singleton Law Firm receive 1099s?
It depends. The way that we're advocating for it, no. Only Singleton Law Firm would receive the 1099, not the claimant, we believe if we receive a 1099 for the full amount, then the trust is completely covered in terms of its reporting responsibilities to the IRS. If they do it the way that they're currently proposing, which again, I don't think they will, but if they do, then we would each receive one. The claimant would receive one for whatever is taxable. So again, the most common one is non-economic damages for which there are no corresponding physical injuries. The claimant would receive a 1099 for that amount. So using the example before, $100,000, they'd receive a 1099 for $100,000. And if the other two amounts were $200,000, we would receive a 1099 for the balance.
Thanks, Jerry. And there's a question about if you have an idea of how much time between the claim submission and the initial offer is going to take.
Yeah, that's really the $64 question right now. We don't know when the initial offers are going to be made. And so again, we're hoping it's November, December, but right now we just don't have that. Going forward, and I think after that first group of offers are made, it's going to be pretty quick, because I think they're going to kind of they're going to find their footing after that, and they're going to be able to run these things through pretty quickly.
Thanks, Jared. Again, there's the follow-up to that is if Singleton Law Firm is issued the 1099, does that change the amount of money that goes to the claimant?
No. I mean, the amount you're going to get is going to be the same no matter what. The only issue is, are you going to get a 1099? And again, we believe very strongly, for a number of reasons, that it would be completely inappropriate to give out a 1099. And as expressed the best by our tax expert, there are so many variables that there's no way the trust can know for certain whether or not a 1099 is necessary. And because of that, there is no requirement that they issue one. The better way to do it is simply to issue a 1099 for the full amount to the attorney, which is the way it's always done in these types of cases.
Thank you, Jerry. And then there's questions about the interviews that are occurring. When will I be interviewed for the emotional distress portion of my claim?
Typically, the way that we do it is that when everything else is done, so when we have all of the reports that we need, when we have your personal property list, when we're ready to submit, but for that piece of information, then we'll do it. That said, again, if you want to get it done earlier, then just contact the office. Serena, who is the lead paralegal on this case and works in our Sacramento office, is the person to contact, and she will set you up with one of the people that conduct the damages interviews.
Thanks, Jared. I have a concern here of one of the clients is that they started their claim late, about 2 months ago. Mm-hmm. Is there a danger of missing the December 31st deadline if they're still awaiting medical records for family members?
No, if we don't have what we need and the date has not been extended, then we'll just go ahead and submit. So if for some reason we needed medical records to perfect a claim, but the trustee refused to extend the deadline and the deadline was the 31st, then we just go ahead and submit, put in a notation that medical records had been ordered and not yet received, and then supplement once they were provided.
Thanks, Jerry. Another email I received is wanting to know if the amount of money the trustee has been paid to date is available.
Yes, it would be. I don't know it off the top of my head, but there are reporting requirements that are quarterly. So I don't know if paid to date would be available, but certainly paid as of the end of the last fiscal quarter would be available. And then once the next fiscal quarter ends, we could find out as well. And that's true for all expenses. The trust has to report its expenses on, I believe it's quarterly. It may be yearly, but I think it's quarterly. So if that's something you're interested in, send me an email and we can find out.
Thanks, sir. I'm going to continue to scroll down through my emails, but you can open it up.
All right. So who has a question? Just go ahead and please unmute yourself and let us know. Yes.
Hi, Jerry.
Neelam, go ahead.
Do you know how many claims they have processed so far? I mean, how many y'all have sent in?
I don't, and I want to make sure I understand. Did you say how many claims the trust has processed so far?
No, how many have you sent in?
Right.
Sent in.
Understood. Off the top of my head, I don't know, but I know people are curious about that, so I will find out. And on next week's call, I'll let everyone know how many we've submitted.
Okay. And when will I know when mine is put in?
If it was submitted at the very beginning, then it wouldn't have required your signature. But assuming that it wasn't, it will require your signature. So as soon as they contact you and you sign off on it, that's when it'll be submitted. If you want me to find out, please just send me an email. I'll look at it tomorrow and get back to you.
And what is your email? I've been looking for that and I haven't been able to find it.
Sure. No problem at all. It's Gerald, Gerald, at SLF, Sam, Larry, Frank, SLFfirm.com.
Okay. Thank you so much.
Sure thing.
I have a question, Jerry.
Yes, please.
I'm not really sure how to present this, but okay, for let's say interest rates on our house. I was in a 3% interest rate. I'm self-employed there, and my business has gone down quite a bit because Paradise burnt down. I'm in the delivery business, and there's no way I could get that rate again. I'd be up in the 6 to get another loan. Is that submittable? Is that anything?
Yeah, that's definitely something that you can submit. Just make sure that you have the documentation for it, and then we can go ahead and do it. Whether they will pay it, I don't know, but it is an actual loss, so I think it makes sense to submit it.
Okay, thanks, Jerry.
Sure thing. Who's next? Chewy, do we have any emails or anything in the chat?
Nothing else has been submitted through the chat, and I don't have any more emails.
Okay. Well, let's give it a second to see if anybody has any questions.
Hello?
Yes, please go ahead.
Hi, I'm not sure if you're hearing me.
I am.
I have a question. PG&E, as a result of the fires, I'm in the Bangor area where we had the 2017 LaPorte Loma Rica fires.
Yeah.
As a result of that, they were ordered to go through and clear all the lines, and they're supposed to be doing tree work. In that process, they've sent so many people on our properties looking at trees. They've had several people come in. They finally agreed to, on my property, one of the trees is a huge maple. It's rotted at the base. They agreed last summer to take it out. It was supposed to have been out by December, and they still haven't done it. Every time these winds come through, it's a hazard, and it's still adding to the trauma of not having that done. Is there anything that can be done about that?
Yes. We're going to need to address it specifically. So the best thing to do is, again, just email me. And when this has happened in the past, what we do is reach out to the risk management people at PG&E, and all we do is let them know, here's the situation. In the event that something happens, not only are you going to be liable, but we're going to seek punitive damages because you knew about it and you unreasonably delayed. And 9 times out of 10, now, I mean, obviously we're going to be nice about the way we phrase it, but when you convey that message, typically we've had pretty good luck in terms of getting them to respond.
Okay, good. That's what I was hoping to hear. One of the
Sure.
last guys out said that to talk to PG&E's Forester. He's the one in the top that gets stuff done. So
Yeah.
But
Yeah,
that's
no,
good.
and what we'll do, like I said, is we do a letter, we CC PG&E's general counsel, we send it to the risk management people, and we say, look, here's the situation, here's what we understand the facts to be. Obviously, as you know, if this happens, and if, God forbid, there were to be an accident, you would be exposing yourselves to punitive damages because of the unreasonable delay. And again, you know, typically we've had good luck with that. Can't guarantee it'll work, but we're certainly happy to do it. And if that doesn't work, then we can take it up the chain, contact the general counsel directly, see if we can get something done.
All right, thank you. I will email you right away.
Sure thing. Okay, great.
Hi, Gary. My name is Rick.
Okay, go ahead.
My wife and I had submitted the claim shortly after the fire within the first 2 months. We've been contacted since then by 3 different either attorneys or people that work for you. And with those contacts, we've added some other things as they came to mind. Question is, by adding to the claim, are we moving ourselves further down the list, or is it the initial date that we filed the claim puts us in the first people that we're filing?
Yeah, it's the latter. You can supplement at any time. So, and this goes for everybody. If you've submitted your claim and then all of a sudden, you know, you have items, obviously if it's one item, it's probably not worth it unless it's significant. But a lot of times people remember things and they make claims later, and we can supplement at any time. So that's not a problem.
No, sir.
I think Mr. Olson had a question.
Okay, so bottom line.
Go ahead. I'm sorry. Go ahead. Go ahead.
I was just going to say, so the bottom line is though that we are in that first group, or likely to be, where we had filed, like I say, within the first 2 months of the fire initially, as far as signing the contract and whatnot with you.
Right. Right. Absolutely.
No,
All right.
sir.
So,
Thank you.
yeah,
Thank you very much
Mr.
for
Olson,
your
go
time.
ahead.
How are the attorney's fees going to be managed? In other words, let's say I had $600,000 of a claim, and you're going to get 33%. Would the claim be buffered up to 800,000, for which you would get 200, or would you take the 200 out of the 600, in which case we would get 400? Or would it be something in between or some other methodology?
Yeah, the way that it's going to work is that everything is added in. So whatever the damages are, they're all added in, and then from that we get a third. That would include the amount that the trust reimburses for attorney fees. That would include economic damages, non-economic damages, everything else, and that's the way that it's done.
But the trust is going to allocate money for attorney fees? They're not?
They are going to award money for attorney fees. What we've asked them to do in terms of an allocation is not break it down, because if they break it down and they do it item by item, then certain things are taxable, and then they would be required to issue a 1099 for those items. So what we've asked them to do is just to pay a lump sum that includes everything. The attorney fees they have to pay, the economic damages, the non-economic damages, you get to one number, and then if you do it that way, then there's no requirement to issue a 1099 to the individual.
And one more question. Do you have any guidance or estimates or methodology for how the emotional distress and the non-economic damages are going to be calculated, or what they will be based on previous cases?
Yeah, I think they'll be based on previous settlement amounts. I mean, that's basically what we've been told by the trust. and that's what would make the most sense. So, depending upon the type of case, it might be a small amount, it might be a large amount, but it'll use the factors that we talked about: proximity to fire, loss. So if you lost your home and everything you owned, obviously that's different than if you lost trees. All of those factors will be taken into account, and then they will make the determination based upon what settlement amounts for non-economic damages have been in prior cases.
Right. But you don't have any idea of what those kind of figures will be.
I really don't. It's also gonna depend on how the trustee wants to do it in this particular case. I mean, there's one theory that they're going to focus on economic damages and make them the prime focus, and then have less awarded in non-economic damages. We just don't know. I mean, typically in these settlements, economic damages have been the focus, they've been the driver, and the non-economic damages have been less, but we just don't know what he's going to do.
Thank you.
Sure.
Napa's committed to serving our communities, and we're glad to extra mile.
I have a quick question.
Yeah, go ahead.
So during this process, because will, for instance, evidence like video evidence of my son having severe asthma attacks that we were able to capture, will those things be presented at some point to drive home the point that, look, this is what happened in the case of my son?
Yeah. When used properly, video evidence can be very, very powerful. One of the things we do anytime we have a wrongful death, serious injury, anything like that, is we prepare a video. And that is what we use for the non-economic damages. In your specific case, I think a video of your son suffering an asthma attack is powerful, and I think that would be good. On the other hand, a lot of times, particularly if it's significantly after the fact, it doesn't make sense to do videos, because I think that it can backfire on you. A lot of times it's better to present it in writing and just kind of state the facts. But it's a case-by-case basis. Given what you described and your son, and I'm sorry that he's going through that, but him suffering an asthma attack, that's powerful. And so that's something we'd want to present.
Okay. Yeah, it was during the time. I mean, we're talking within days or week.
Oh, absolutely.
Of when it was happening.
Yeah, something like that is great. What I find to be less powerful is when you have people talking about, in a stoic way, the loss of their home, just because a lot of times it just doesn't come through. It's one thing if you're talking about the loss of a loved one, then it really always comes through. But a lot of times people are able to kind of compartmentalize, and they're able to say, well, I'm better off than other people. And so when you have them describe it, it just doesn't come across as well as when you just lay out on a piece of paper, look, this is what they lost. The person reads it and thinks, my God, that's really something. So yeah. Again, it's a case-by-case basis. We really try to be judicious about it and use it when we have something that's going to be powerful, because I think it really gets their attention when you do it that way.
Okay. And then the other question I had was, what will there be a point where your firm will conference with my wife and myself to discuss the strength of our particular claim, and then kind of help us to understand, maybe, for instance, why a piece of evidence that we submitted was not used or would be used? You know what I mean? Just to kind of assess, okay, I get it. We know what the game plan is.
Yeah, I mean, obviously you're welcome to talk with us at any time. I mean, typically the way we do it is there's the submission. And so the client would talk with the attorney or paralegal who's getting their approval. Then you sign off on it, and then we'll get the offer back. And when we get the offer back, then we go through and we say, okay, here's how we evaluated your case. Here's what we were thinking. Here's what the offer is. This is our recommendation, and this is why. and then you make the decision.
Okay. Okay. Thank you.
I don't have any more messages here, Jer.
Okay. Do we have any more questions?
Yeah, I have one more question.
Sure, go ahead.
Considering that, let's assume that the stock price remains as it is, more or less, in which case I believe the trust is going to take a look at the projected value of the trust, and at a certain point after they're receiving several thousand or some number of claims, make an assessment as to what percentage will be paid out and what they think, give some realistic expectations of what's going to be, how the claims are going to be funded. So will any of those calculations or be public?
That's an interesting question. I don't know the answer to that, but it's certainly something that we can find out.
Okay.
Yes, I have a question.
Please, go ahead.
I was concerned about my FEMA award.
Mhm.
So one of my FEMA awards was just an initial award, and the other one was a grant. And so is FEMA going to try to collect the payments back from our settlement? And if they are they going to do it in the 2 stages like you will with your attorney fees?
No, FEMA is not. We reached an agreement with FEMA, so they're not going to do that. Now, the trust has the option of, if you received money for a specific item, like let's say you were awarded $5,000 to pay for personal property loss, then the trust could say, okay, because you received that $5,000 for personal property, whatever we were going to award for that amount, we're going to reduce. I don't know if they will or not, but that is an option they have.
I see. Well, that one's not the case. They did not specify. They specified that I keep the receipts for several years, but no. But that's good to hear, and I really do appreciate all the work you've done on our behalf. So thank you.
My pleasure. My pleasure. We really want to get you guys paid. I know I sound like a broken record, but I understand how difficult it is. We want to make sure that everyone gets paid, and we're pushing on them. So we're really hoping that the offers go out in that November, December timeline.
Great. Thank you so much.
Sure thing. Okay, do we have any more questions before we wrap up?
Hello?
Yes.
I just wanted to add a thank you to the woman that just told you. I also really appreciate you. Thank you. Bless you.
My
Okay.
pleasure. Like I said, I love doing this, so it's really my pleasure. Okay, so let's wrap up. If I know there were a couple of folks that were going to email me about specific things, please do that. And then in addition, Chewy, I know there was something that we were going to look into. I believe it was the number submitted, and we were also going to see if we could find out the total number submitted. So let's make sure we do that, and we'll have that information available next week. Please take care, stay safe, and we'll talk to you then.
Thank you.
All right, bye-bye.
Thank you.